Good afternoon and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulo Hoyani. This afternoon and evening, I would like to go back to that Section 174 application, which the defense intends to bring up in court on the 7th of August when the case resumes. Let us take those issues a bit further by looking at the evidence that has unfolded in this trial. Remember, I've always said the 174 application focuses exclusively on the evidence that has been led in court. In other words, the prosecution cannot at this stage bring in any evidence outside the evidence that has been led by the prosecution. In other words, all they have to do is to look at the prosecution witnesses and, try and poke holes in that prosecution evidence by way of showing inconsistencies, by way of showing, its weaknesses, which then will raise doubts about the guilt of the accused persons. One of the most important things that the defense must do in this application is to go back to the evidence of Brigadier Gininda. You see, Gininda is very central to this trial. He has styled himself the lead investigator, although Warrant Officer Makubu has since come before that court to tell us that none of the investigators in this matter were ever appointed or designated as lead investigators. Anyway, let us look at Gininda, let us look at Gininda and see what Gininda is all about. You'll recall that Gininda has told the court that at the very earliest stages of this investigation, there were differences between two sets of investigators. In other words, there were those who held the view that there had been intruders into that house, and there was another set of investigators that came up with the view that there were no intruders into that house. So that is the starting point. This will be a very crucial way to put matters into perspective, to sort of say to the court, much as we have these people before this court, and evidence is being led against them to the effect that they are in one way or another involved in the killing of Senzo MEYIWA. The prosecution, by its own admission, has clearly indicated, the prosecution has clearly indicated that, there is another parallel process. There is another parallel process, and that parallel process probably has got nothing to do with the accused persons before court. So Gininda has come up with this evidence, and it is very crucial that it is Gininda who came up with this evidence. So what is the parallel narrative now? The parallel narrative that Gininda was alluding to or referring to, although he did not do that in so many words, the parallel investigation or process of investigation that Gininda was referring to is the narrative of 375. This court must in no uncertain terms be told that there are two dockets involved here in respect of one murder investigation, and that there were two sets of, investigators operating out of the same Foslo-Ras police station, such that two dockets, two mutually exclusive dockets, two dockets that are so different from each other, were opened in the same Foslo-Ras police station. You see, that is a very important issue. It is important because it is coming out of the prosecution. Remember, I said at the stage of the trial, all the defense must focus on is the prosecution evidence so far accused. So this is evidence that comes out of the prosecution, right? So that the existence of a parallel docket with a different narrative that says there were no intruders into that house, the narrative of docket 375, will then cast aspersions or raise doubts in the mind of the judge as to whether these are the right people that he has before that courtroom answering to that murder charge. That will be very, very important for the defense to raise up. Because you see that there can never be a situation if people find themselves before the Pretoria High Court and they are being charged with something as serious as murder, and there exists, coming from the prosecution itself, there exists yet another docket that says they have got nothing to do with the killing of Senzo MEYIWA. Although that docket has not actually been brought before court because they couldn't bring two dockets before court. Right? They couldn't bring two dockets before court which were, mutually exclusive. But the existence of that parallel docket, what I'm trying to say indicates that the whole thing was a fishing expedition, right? And that the court runs a real risk of, convicting the wrong people. The court runs the real risk of convicting the wrong people because if there is a separate docket with a different narrative from the one unfolding in court, then surely that possibility exists that there are other suspects out there, who ought to be sitting in that dock and not the accused persons. That this is the starting point. So in the application for the discharge of the accused, the defense must focus on this aspect. And you see, this aspect is important because, like I'm saying, the defense is confined to the evidence that has been led so far in court. And this is evidence that has come before the court through Brigadier Gininda. Right? Now, the issue that the court has to address will be, what was Gininda talking about? What was Gininda talking about? I mean, if Gininda himself concedes that there is a separate docket, different from the one that he has placed before the court, right? Gininda, by admission, is saying the evidence that we are putting before this court might probably not be definitive enough or conclusive enough, to link these people with the murder of Senzo MEYIWA. They may well be other people out there, and this is Gininda saying it. There may well be other people out there who are guilty of this offense and not the accused persons that we see sitting in the dock. So this issue of the two parallel dockets is very important to sort of put matters into perspective going forward. And once that has been done as some kind of foundation, then the defense can then move forward onto other witnesses. But having said that, I promise to keep updated about how the defense can approach this Section 174 application in the run-up to the 7th. But I think this, in my opinion, will be a very good starting point. Thank you very much and have a wonderful afternoon and evening.